Yes, good morning.
Good morning. May it please the Court, David Hoos from Northampton. For the appellant in this case, Anthony Baye. Seated with me at counsel table is Attorney Thomas Lesser, co-counsel for Mr. Baye. This Court has had numerous opportunities over the past 150 years to try to set up some guideposts and some warnings on what is fair practice in terms of interrogation procedures. I don't think it would be a good use of my time to attempt to try to go through all of those cases, yet I think it would perhaps be useful to touch on a couple of those just to give the framework for which the Court should be reviewing the tactics that were at issue in Mr. Baye's case. Certainly in the modern era, the starting point would probably be the oft-cited footnote 8 of Commonwealth versus Jackson in 1979, in which this Court expressly pointed out the problem with deliberate false statements and the effect that they could have on an interrogation. In that same year, the Court ruled in Meehan that statements to a suspect during interrogation that his guilt had already been determined were problematic, and condemned statements suggesting that a confession would be helpful to the defense. In 2004, of course, this Court dealt with two important cases, first being Commonwealth versus Novo, in which the Court suppressed a statement because of the misrepresentation of the legal consequences that was conveyed by the interrogators. In that case, the legal consequences being that you either speak now or you will never have an opportunity to have a jury hear your side of the case. And then, of course, this Court's decision in Dijon Batista, which to a degree not present in any of the prior cases, talks about the concept of minimization as being problematic, and expands upon the warning of Jackson in footnote 8 by saying that false statements plus promises of leniency are really going to be problematic. And finally, just a few months ago, this Court in Tremblay, very sharply divided court, found the statement that was given in a response to an assurance that it would be off the record admissible, but as Justice Spina's majority opinion emphasized, slightly different facts could lead to different results. All of the tactics that I have touched on in the cases that were just mentioned were present in the interrogation of Anthony Baye, and present to a degree and to an extreme not heretofore seen in any reported Massachusetts decision. And in addition, the interrogators in that case introduced a couple of themes for which I have not been able to find explicit decisions within the Massachusetts case law, although they are certainly not unheard of in other venues. Those being an explicit promise not to charge or accuse if the interrogation could continue. And second, statements by the interrogator, again to a degree not reported in any of the other cases, that he was on the defendant's side, that he would champion his cause with the district attorney, that he would stand on his soapbox and go to bat for him.
Let me ask you this. I think it's fair to say that all of these pieces are before us in the tape, in the transcript, and we can certainly see it, as did the motion judge.
Right.
But the motion judge, as I recall, focused on the effect of these tactics and essentially found they were of no effect. I mean, isn't that something we should consider as to whether or not this is a voluntary act?
In that respect, I have to respectfully disagree with Justice Sweeney's findings, and I think that, as this Court has said, you are free to, because of all of the evidence, all the significant evidence on videotape, to review it and draw your own conclusions. I think that her conclusions, when you read her opinions, are erroneous in a number of respects. First of all, her findings as to when the first acknowledgement of responsibility begins is clearly wrong. She says that it happens after they're sitting and looking at a map, when in fact the first statement from Mr. Baye acknowledging some minimal responsibility, the nugget that Trooper Mazza kept begging him to give him, comes after an impassioned plea from Mr. Mazza, which is at the end of one of his monologues, and in which he says, do you see that I'm on your side? Do you believe that I'm on your side? And Mr. Baye responds, yes, I really believe that. I really believe you're on my side. And shortly thereafter that, he picks up a theme that he runs with for page after page after page, that this is an accident. This is nothing more than an accident. And again, Mr. Baye's first inclination to give an inch is in response to a lengthy plea by Trooper Mazza of, Anthony, it's an accident. I know it was. I know it was, Anthony. Anthony, tell me it was an accident. Anthony, yes. Yes, it was an accident. Wasn't it an accident? Yes. Say yes, Anthony. And Anthony says yes. That's the first time he acknowledges it, and that contradicts Judge Sweeney's conclusions completely.
He had already, Mr. Baye had already at that point seen the maps and seen the photographs, and all that information was already before him. So that part is not incorrect. It's just a question of the proximity, temporal proximity of that I gather is your point.
That's correct. There's no doubt that he looked at maps and photographs early on and again later on in the case. Justice Sweeney also points out in her decision that there were no misstatements of facts, and I think that is clearly wrong. It's not something that we have made a great point about in the course of our briefings, because as this Court has held many times, misstatements of facts standing alone without more oftentimes do not lead to suppression. There were misstatements of facts, the most significant one being the statement that Trooper Mazza had enhanced photos which showed that this was Tony Baye getting into his car. That's you, that's your car. And significantly, I think, for this Court to understand how effective the psychological domination was of Mr. Baye agrees at some point that must be him. And of course we now know that in fact wasn't him.
Is there any evidence that the trooper knew at the time that it in fact wasn't him?
Well, I don't know what the trooper knew that it wasn't him. I can tell you
the FBI didn't even provide this information after its laboratory work until after the motion was even decided.
Right.
Long after the arrest,
Right.
long after all of that.
Right. I think the point, however, to be made is that the way that was expressed to Mr. Baye was that it was beyond doubt that it had been enhanced. It was the kind of incontrovertible evidence that this Court has referred to as being problematic.
It was a photo of him and his car, allegedly, right?
It was a photo that purported to be of him in his car.
And he saw it, and let's assume the trooper said in good faith, "This is you," and he said, "Yeah, I guess it is." I mean, I don't understand what the basic problem is there.
Well, I think the problem is that it was presented to him in such a way, in the context of all the other things that was said, was that it was futile to deny it. And that's one of the themes that it comes back.
Didn't they say they could make out the license plate number?
Well, exactly. And Trooper Mazza testified at the hearing that he had computer-enhanced these images. that he had used a magnifying glass and that he could see that it was his license plate. Here's the number 8 here. You can see the number 7 here. Now, I can tell you those photographs are in evidence, and if any of you can see that, you have better eyesight than I. I think that it was an exaggeration, and again, exaggerations of fact. This was just one of a few. He also...
Were there other photographs, though, that the FBI hasn't established that were not him and his car?
There are no other photographs.
This is the only photograph that was shown to him.
That's correct.
In the course of the interview.
I believe that's correct.
I mean, the
Justice
judge
Cordy.
refers to photographs, and I don't...
He refers to computer enhancements. He refers to this photograph that we're talking about came from a cruiser cam. He refers to other cruiser cams. He refers to surveillance photographs. He refers to eyewitnesses, none of which I believe exist or certainly are not a part of the record. Yet these factual misrepresentations are really a small part of the problem here. What is of much greater concern and should be of much greater concern to this court is the repeated legal misrepresentations that were made by Trooper Mazza. And I think it's significant that Judge Sweeney found that Trooper Mazza blatantly and repeatedly misrepresented the law of homicide. He talked extensively for page after page about accident and mistake. And I don't think we should lose sight as members of the legal community about the vernacular meaning of those words. Every child knows that you don't get punished for something that's an accident. You don't get punished for just making a mistake. This begins after his first efforts to get Mr. Baye to talk, in which he tries to talk about the incidents as just being tomfoolery and just pranks, and that people who commit pranks and do this kind of tomfoolery, this beer-filled silliness, should be treated in one way and not be treated like arsonists. Later on, when that is not effective because of Mr. Baye's assertion of his right to counsel, he returns after getting Mr. Baye to talk about accident and mistake, and that becomes the primary theme. I know that just in one section of the transcript, we counted that the word accident had been used 75 times by Trooper Mazza. Now, using the terms accident and mistake are problematic in a couple of ways. The first of all, they are the kind of minimization that I think the court condemned in Dijon Batista. And I say that acknowledging that not every minimization renders a statement involuntary, but the repeated repetition of a suggestion that this is accident or mistake carries with it the obvious conclusion that either there will be no penalty or that the penalty will be very slight. But in addition to just being improper mitigation, it is a much more serious form of misrepresentation because it is a misrepresentation of the law. He repeatedly tells him that there are exceptions in the law where you don't intend the death. And this is, of course, interspersed with his other assurances of the things that he can do for him. We can work some magic here. You're going to like what we can do with this. And the point is that he continually represents and suggests to Mr. Baye, he does more than suggest it, he asserts it unequivocally, that if you don't intend the deaths, then you're not responsible for them. And as if that is not clear enough example in and of itself, he goes on to further misrepresent the law of homicide by talking about causation. There are times when we're talking about the Fair Street fires, which is where the deaths took place, where Mr. Baye is told by Trooper Mazza, look, do you know how long the Amherst Fire Department took to get there? 20 minutes. Is that your fault? Of course it's not. These people were hoarders. That house went up like a tinderbox because of the stuff they hid in there. Is that your fault? Should you be responsible for that? Of course not. So there is this repeated misrepresentation of the law. I realize I'm out of time, as usual, much more quickly than I'd like. And with the Court's permission, I would just like to add one sentence on.
May.
This also raises an issue not heretofore presented by the Court, and that is the promise not to charge and not to prosecute. And it's very clear. It is almost offer and acceptance. Trooper Mazza says, we'll talk to you under any conditions you want. And Mr. Baye says, if you promise you won't accuse me or charge with me, then you can say whatever you want, but I'd still like a lawyer present. And if that's not clear enough, Trooper Mazza again later on says that he will go to the district attorney and see that he is not treated as a criminal. I would ask the Court to look very carefully at the cases, many of which are cited in Justice Gantz's dissent in Tremblay, as to the problems that such a promise creates for a suspect to make a rational decision as to whether or not to speak to his interrogators when he has been promised that he won't be prosecuted. I thank you very much for your time.
Thank you.
Thank you.
Mr. Chief Justice, members of the Court, my name is Brett Votero. I'm a Special Assistant District Attorney for the Northwestern District. With me today are Matthew Thomas, Assistant District Attorney, and Tom Townsend, the Chief of Appeals for that office, and we represent the Commonwealth. Before addressing the techniques that have been brought to your attention, I want to make a quick point. On January 4th, Anthony Baye was 25 years old. He was employed. He owned his own car. He lived independently. He was articulate and intelligent, attending college after obtaining impressively high scores on his SATs. He was alert and sober, calm and focused. And in the week preceding the January 4th interview that we're discussing here today, he was questioned by state and local police in 4 separate interviews. In these interactions, the defendant demonstrated his intelligence and his ability to control his own destiny through deliberate and bold falsehoods, and it is undisputed.
Can I ask you a question? What you're driving at there, is it that somehow when you have a more intelligent defendant or more intelligent suspect, you can use more coercive techniques?
No. What I'm driving at is that, as we know, the ultimate test, applying the totality of the circumstances, considers all of the factors, including the ones that I've just mentioned. And it will consider the techniques used. I certainly agree with that, Justice Link. One thing that is not disputed in this case, and has ever been disputed, is that even after 10 hours of this interview, Anthony Baye retained sufficient free will and rational intellect to deny any involvement in more than half of the 15 fires charged in these indictments, as well as involvement in numerous fires set in the neighborhood in Northampton. I want to begin where defense counsel ended by suggesting that there was a promise not to charge. If that were true, that would be very significant indeed. And how do we know that is not true? Well, if this court does apply a de novo standard, and as you watch the full 10 hours of this interview, and I hope that you would watch it with the transcript underneath with headphones, it enhances it tremendously. When you watch that, you won't hear it. You'll have to go back and replay it. Well, that's the first point.
You will hear, I gather, the words from Trooper Mazza, I promise you an accident will be treated like an accident. I will portray it that way and call the dogs back. I promise you that.
That is one of the things that you will hear in the 10 hours of interview, no question. But on this one specific point, whether there was a promise that he wouldn't be charged, I want to suggest to you that if Anthony Baye or any reasonable person in his position had believed that was the case, that would be item 1 in his affidavit in support of the motion to suppress. I urge the court to look at that affidavit. It's not there. I urge the court to look at the defense pleadings in the case. It's not there. It's only after we sat for 3 days and watched it all, that suddenly the defense realizes, listen, go back and look. There's a promise of immunity. Now, why do I make this point? Because what you have heard, both today and to a large extent in the brief, is like the preview of a coming movie. You've got the highlight reel. And when you watch the full 10 hours, you will, as Justice Sweeney did, have a different impression.
I just want to be clear. Are you saying that, excuse me, no such promise was made, or a promise was made but you can't hear it because it's not?
No. I am saying, Mr. Chief Justice, that it is unfair to interpret what took place as a promise that he wouldn't be charged.
Okay, but what do you interpret a promise that will be treated as an accident to be?
Well,
What does that mean to a reasonable person, or to a person who's under interrogation?
Well, I think to either a reasonable person or even a reasonable jurist, when you watch the full 10 hours, you will hear that word accident repeatedly, time after time. But what you will hear is not what's been suggested. What they're leaving out is that every time that is discussed, it is discussed in the context of the deaths. Trooper Mazza was investigating a series of fires. He never once suggested that these fires were accidental. What he was driving at in all of those questions was, did you intend to kill these two people? Or were their deaths an accident? And that would be what, as counsel has noted, what the common sense understanding of accident would be. We understand, those of us trained in the criminal law, that if you set a fire and somebody dies, whether you intended it or not, you're facing some serious trouble. And words like murder and, double first-degree murder, those words appear in that 10 hours. So I want to caution the court that it's so easy to pull out phrases that make, even as Judge Sweeney said, some cringeworthy moments in the interview. But when we look at the totality of the circumstances, you will see that all of the discussion about accidents relates to whether these deaths were intended. Did you set out to do that? Or was that an accident?
Right. But that's a mischaracterization of the law of felony murder, because it doesn't matter.
I think I would agree it's a mischaracterization of the law of felony murder, but I would disagree that when we watch the tape, that is what Trooper Mazza is doing, is explaining the law of felony murder.
What do you think it is?
I think he is trying to get the defendant to tell him, did you intend to kill these people or not? Now, that's a relevant inquiry. And for any judge who has ever imposed a sentence or any counsel who have ever argued sentencing, that's a fairly significant fact.
That's sort
First-degree felony murder doesn't matter.
That's correct, but it won't be Trooper Mazza that's deciding if it's felony murder.
But it's framed. But if it's framed to a reasonable person to suggest that if it was an accident, there's no problem here.
I think that would be. I agree, it's a problem to minimize what the consequence might be, and I certainly don't dispute that what we've seen in many of the questions was minimization. I don't want the court to think otherwise. Minimization is present. But let me deal for just a moment with the idea that falsity took place. Judge Sweeney found there was no falsity. She made a specific finding that they never misrepresented the strength of their evidence, ever. And yet the defense suggests in their brief that because Trooper Mazza said, I have a fabulous case, that's improper. But this court has painfully noted in any case where you have reversed because of a police deception, it's a direct deception. It's the assertion that I've got an eyewitness who's known you for years that says you were there in Meehan, and it wasn't true. Okay. I've got your videotape of you in the area in DG and Batista, and it wasn't true. That's not here.
If I could follow up, in Judge Sweeney's very careful and thoughtful decision, there's one part that I thought was confusing. She says he's not in custody because although the trooper said we have overwhelming evidence, no reasonable person would have believed it. And then she later says, well, he confessed because he recognized the overwhelming nature of the evidence. And I guess is there a contradiction in that? And firstly, if a police officer tells somebody that there's overwhelming evidence that they're involved in fires which resulted in a death, should that not lead a reasonable person to believe that he's in custody?
I think it would be a factor you would consider. But when you consider that this interview begins with him being told you're not under arrest and you're free to go. And at one point in the interview, in fact, the critical point, if you read the defense case, when he's made this reference to a lawyer, they make it clear to him, if you want to go talk to a lawyer, you can. So it's hard to find custody, even for a reasonable person, if the police are saying, you know, go talk to a lawyer if you want.
Let me ask you on he was given Miranda warnings at the commencement of this interrogation.
Yes, Your Honor.
Did he sign a waiver?
He did not sign a waiver, but we have the videotape of the administration of the warnings.
And did he waive his Miranda rights?
He did.
And that's on the video recording?
It is.
Okay.
And I think there's some testimony from Trooper Mazza because he had previously been administered his Mirandas during, I think, the third interview that also took place.
But on the question of if you want a lawyer, go. Maybe it doesn't show custody, but doesn't that become another misrepresentation because he says, well, if you're going to accuse me of anything, I want a lawyer, and then they go on and say, no, just talk to us. So.
I think far from being a misrepresentation, I think when you watch the videotape and you watch that segment in particular, you will see police officers trying to do what the courts have encouraged them to do, where there's some kind of ambiguity about what the person wants, to clarify it, to affirm that right. And they did affirm that right. They told him he could leave. They told him they couldn't talk to him if he wanted a lawyer. And I think when we watch the whole tape, that's what we'll see. There is one point that I want to make about both the defendant's brief and also it relates to DGM Batista. There's just a passage in the defendant's brief that suggests there was no evidence corroborating Anthony Baye's statement. It's there, and it's there for a reason. It is there to make you question, as a court, whether this confession is reliable. And the problem the Commonwealth has is we are between a rock and a hard place in this area. The U.S. Supreme Court says that on the pretrial determination of voluntariness, it is constitutional error for a court to consider issues of reliability. It is constitutional. In fact, they found it so important in Jackson versus Deno that they said we don't trust juries to do this. And yet, if we look even at the opening paragraph of DGM Batista or the defense brief here, it is clear that issues of reliability are coming into play. The Commonwealth could not, in front of Judge Sweeney, properly introduce any evidence to show the strength of its case, that this confession was reliable, and yet, on appeal, we are challenged, and the court is asked to believe that this confession is unreliable. And we cite this issue of minimization, which we've raised in our briefs, the challenges to minimization. And the expert who testified for the defense in front of Judge Sweeney challenged that not on basis of voluntariness, but because it produces false confessions. These are two very different things. And we accept our burden to prove reliability. And we will. To the trial court. We accept our burden to prove voluntariness and know that these factors are part of that. But when we walk, we're stuck. If the court is thinking about reliability issues in voluntariness, we can't dispute it because we would be violating the federal Constitution. And if you rewritten DGM Batista, kept the same opening paragraph and said, but we think it's voluntary, it would have been reversed. Because you would have allowed reliability factors to infect the analysis of voluntariness.
DGM Batista didn't turn on reliability. It did not turn on reliability.
I agree with you, Justice Cordy, but I think you would agree that the language of DGM Batista and the studies that are cited all are discussing how minimization increases the risk of false confessions.
Well, and impacts voluntariness.
It does.
Sure.
Which
does both, as it turns out.
Which is why the Commonwealth in this case said to Judge Sweeney as we began the hearing, it was an unusual circumstance. Both sides agreed that we wanted Justice Sweeney to watch in open court all 10 hours because both sides embraced the totality of circumstances analysis. And if we do not give any deference to Judge Sweeney, then as a trial lawyer, I'm a bit of a disadvantage in trying to replicate it in 15 minutes before this court. But if you do that, I trust that after you watch the full 10 hours, you will have a different impression. And one of the things you will come down to is the ultimate question, which I began with, the ultimate question that Judge Sweeney ultimately reached. Yes, she said, I found some of their techniques offensive, improper. They were against advice given by our Supreme Judicial Court. But I also determined that this defendant, Anthony Baye, intelligent, articulate, sober, coherent, calm, and rational. In fact, watch closely. He's quite talkative in the first hour of the interview, where he's giving his false alibi. He's clever, and his will ultimately was not overborne. You know, the words rational intellect and free will mean a lot when we reach voluntariness. And if you go back to look where those words came from, they came from the Blackburn versus Alabama case, where somebody who was diagnosed as insane by multiple state doctors was held incommunicado and was asked to sign a document that the police produced. When we watch 10 hours of this interview, we see Anthony Baye holding his own, denying what he wants to deny, admitting where he feels the facts compel him. It's not this cruiser cam video, which is not part of our record. That's not the critical fact. The critical fact is that his plate is being run by one officer and by a second officer at a time when he's made it ironclad clear he's allegedly with his friend. That cruiser cam video is simply another piece of evidence. And it was one that, until the FBI report came back, the defense believed showed Anthony Baye getting into his car. So it wouldn't have impacted Judge Sweeney, not at all.
This is not related to the result in this case, but I must say I find it troubling. And one or both of these troopers, not only are they extremely experienced, right, but one or both of them are trainers, aren't they?
I think that's correct. I think probably
Is this
both
how
of them.
they train their troopers?
I think both of them are trainers. As to whether that's how they trained their troopers, I couldn't tell you. That wasn't part of the record. Trooper Mazza cross-examination was quite limited. And so on this record, reviewing the full 10 hours, I urge the court to conclude, as Judge Sweeney did, that while the techniques raise some questions and some concerns, on the ultimate issue of voluntariness, the Commonwealth has met its burden of proof and has shown that this was a man possessed of free will and rational intellect, and he made the decision what he would admit to and what he would deny.
Thank you.
Thank you.